Yeah, when I think that the cops have done something wrong, I'm going to file a motion to suppress or motion to dismiss. Look, the word motion, that's just a fancy term for me asking the judge to do something for us. Now, when I ask the judge to do something because of what a cop has done wrong, I might be calling the cop a liar, and maybe that's too strong of a word. It's not as dramatic as you see on TV. And in the case of, for example, Duke v. State, Duke was arrested for driving under the influence. Now, his defense attorney filed a motion to suppress the stop. And if they win this, the DUI is dismissed. It's gone. It's a beautiful thing. We all know this. We all share this love of things being dismissed, or at least I do. Now, the cop testifies that he pulled over Duke for 3 reasons. A wire was hanging down in front of his license plate. Pretty bogus. His car drove over a white line. Double bogus. And Duke wasn't driving in a straight line. Well, maybe the road wasn't straight. I don't know. The officer then added something that wasn't in his police report. Very important. He added that, it looked like Duke was ill or drunk, but I didn't put this in my report. The judge says, I don't believe this cop's testimony that Duke was pulled over because he was ill or impaired. He never put it in a report, and now he's just saying it at the motion. DUI gone. I'm throwing this thing out. Bad stop. Have a nice day. For Duke, it didn't end there, unfortunately. State never likes a beatdown. This is what they received. So they appealed this judge's ruling. Now you got to stay with me here. We're getting to the good stuff. The appellate court looks at this transcript and goes, hey, there's plenty of reason to believe this officer. This officer said Duke looked impaired while he was driving. That was uncontroverted. So they sent Duke back to trial court and said, you're back facing your DUI. You're starting again, buddy. So Duke appeals to an even higher appellate court. And this is where the good stuff comes in. On this second appeal, we find something out very interesting. They look at what the original judge said and did, and the original judge threw out Duke's DUI because he didn't believe the officer. He thought the officer was lying. He didn't find the officer credible. I'm throwing this DUI out. And in a moment of rare humility, that appeals court looks at this and says, well, you know what? We really don't have the authority to decide or believe a cop that the initial judge 6 feet away in the courtroom didn't believe him. An appellate court can't make credibility decisions of witnesses. This original judge in Duke, when he threw it out, looked at that officer, I'm being dramatic, and said, you are telling me that the only reason you stopped him is because you thought he was impaired and you didn't bother to put that in your report? I'm not buying it. I'm throwing this kid's DUI out. Next case. I just don't believe you. These are magic words. These are like Harry Potter words. When a judge says, I am basing my ruling on the credibility or a lack of credibility of this witness testimony, you know what we learned from the Duke case? No appellate court can overturn a decision that rests on credibility. You can't appeal. So when I win a motion and I hear a judge say, I'm basing it on witness credibility, everybody in the courtroom knows, nobody's appealing this. We win, and we win forever. It's a beautiful thing.